Good morning, Your Honors. Guillermo Menzibo for the appellant. I'd like to reserve 5 minutes for rebuttal, Your Honors. Your Honors, the crux of this case is very simple. It's founded on principles of contract rights, property rights, and the basic tenements of aviation and safety. What we have here is a homeowners association governed under Chapter 720 that was built in 3 phases. The first phase being Plat 1, which includes the airstrip and the 2 roadways or taxiways, as well as some other properties. We also have the Plat 2, which is Phase 2, which was built adjacent to one of the roadways, and Phase 3, which is built on the other roadways. By their very design, Plat 1 specifically carved out the airstrip and the adjacent roadways and has a note specifically stating that for utility easements, they are to be placed along the roadways except for those roadways adjacent to the airstrip. Now, this is very important because there are other roadways in Phase 1. Now, the association...
So the only roadways that were designed to be used as taxiways are the ones that are parallel on each side of the runway, the airstrip, correct?
With regards to taxiway, yes, Your Honor.
Okay.
Now,
what about the owners in the Plat 2, the Phase 2? Do they have access to the airport?
Based on my review of the aerials, Your Honor, yes, they would have. They are adjacent to not Aeronica Drive, but Bell Drive. And Bell Drive is the other eastern adjacent roadway. So they also have access to the taxiway strip. As a matter of fact, those properties in Phase 2, their utility lines are within the boundaries of each lot owner. Now, if you look at the plats...
All right, but there's another area in that Phase 2 that goes around the lake.
Correct.
Do those people have any way to taxi onto the airstrip?
They do, Your Honor. And if I can pull up the...
But you're saying that the Phase 2 lines are within the 15-foot setback on the lot owner's property.
Correct, Your Honors. And the key issue is that Phase 2 and Phase 1 all have access vis-a-vis the roadways. Phase 3 only has access vis-a-vis Aeronica Drive. If you place these this utility easement that was created or construed by the lower court, you effectively are impinging upon each unit owner's irrevocable easement of use. Now, that's critical here because the argument from the association is that, well, they have a use right, and that doesn't mean that the Tri-County Electric can't come and use it, or so. And I go, and it's not, because under 720, this is in the homeowner association, or Chapter 720, each unit owner is a member of the association. They're bound by the Declaration of Restrictive Covenants. Now, this Declaration of Restrictive Covenants specifically identifies that the easement is an irrevocable easement of use for owners.
What do you say to their preliminary contention that you did not rely on the declaration in the trial court?
Your Honor, I believe that's false. I mean, we argued the declaration. We also have in the judgment, it's part of how they construed it. It's quoted verbatim. It's also part of our 1.50 issues that the court abused its discretion in not hearing the evidence that was withheld by the appellees. But nonetheless, Your Honor.
Actually, the declaration itself did come into evidence.
Absolutely. Now, the issues here, Your Honor, is Phase 2 and Phase 3 did not replat Phase 1. Now, they're saying that there was ambiguity in the plats, and that where it's ambiguous, I would submit. If they are ambiguous, then yes, the court can rely upon parole evidence to construe and interpret the plats. However, this is very simple. Plat 1 has land that is unplatted, as they mentioned in their brief. Plat 2 and 3 don't show unplatted lands, whereas Plat 1. Why? Because once Plat 1 was platted, it was already platted. So when they platted Plat 2 and Plat 3, they had to include, to identify and show the land that was in Plat 1. But the legal descriptions in Plat 2 and Plat 3 do not include the legal of Plat 1. They're specifically Plat 2. And where it says that the easement for utilities is to be along the road right-of-ways, without the exception language in Plat 1, the reason being is because Owner-occupier Drive and Bell Drive are not part of Plat 2, Plat 3. They will never be part of Plat 2, Plat 3. It's basic property law. Now, again, we go to along the road, not within. They went through the great lengths of showing what is along or what is within. And the reality is, along the road right-of-way, because Plat 2 abuts, Plat 3 abuts Plat 1, where that property line is, you can only go along that property line. You will not, we cannot plat in Plat 3 access to Plat 1 vis-a-vis an easement there. Only the tenant holder of Plat 1 would be able to grant that easement right. And therefore, we submit that the utility easement should fall within those first 15 feet under Ordinance 74.5, which was later discovered, on each unit owner's lot. At the end of the day, it's not a taking of the unit owner's lot, because the lot owners have already a 50-foot or a 30-foot setback, because this is agricultural land. So the fact of the matter is, this was built, the intentions of this property were it to be an air park, fly-in community for aviation enthusiasts. At the time, it was built to commercial standards, i.e. they needed a 200-foot primary surface. So from the center line, they have 100 feet. If we allow this to occur, not only does it fall well short of today's standards.
So from the center line of the airstrip, there's supposed to be 100 feet.
100 feet each way is how this was designed.
Wasn't there some testimony that there were some trees along Aranca that basically are within that 100 feet and make it so Aranca Drive cannot be used as a taxiway?
Yes, Your Honor, there is testimony to that effect, and I would submit, although I didn't try this case, I would submit that that is a breach of the association's fiduciary duty. The board of directors for the association under Chapter 720 has a fiduciary obligation to each owner for safety, health, and well-being of its unit owners, and it is foreseeable.
That wasn't litigated below that issue.
Exactly. And I'm not trying to retry an issue here, but what was said is the foreseeable zone of risk. If something is foreseeable, then in aviation, I'll submit drinking coffee while you're flying the plane. It's foreseeable that you could have a spill and your instruments will go bad. It's probably a good idea not to drink coffee while captaining the plane. I would argue that the installation of these poles, the inclusion of that tree that's there, these ditches, all that is a foreseeable risk with regards to aviation.
Well, counsel, let me fast forward a little bit.
Yes,
These are really good things to think about if you're in the planning stage of a development like
Agreed.
that. What year did your clients buy the property in Unit 3?
I believe, if don't quote me on this, but it was some time ago.
Okay.
It wasn't recent.
And there was already, at least the northern part of the electric line was already installed at the location the developer designated 10 feet within the roadway?
Yes, Your Honor.
And it's now been completed down the entire length?
That's my understanding subsequent to the trial, that they have completed it, notwithstanding this appeal.
Okay, so after the final declaratory judgment, you didn't get a stay, and so they had the legal authority to put the line in. That's where we are right now. The line is in. The
line is in, Your Honor, yes. And I would submit that that line is improper, because at the end of the day, it is infringing on, at the end of the day, what we're talking about here is property rights. My clients have a dominant tenement with regards to the easement that was granted to them. these poles along Aronica Drive do impinge upon my client's use rights.
Well, does the covenant that says you have an exclusive use easement, does it preclude, specifically, expressly preclude utility easement, or does it say what kind of use?
Well, it says, Your Honor, irrevocable. Each unit owner has a non-exclusive, irrevocable use right. Now,
Don't you still have that?
That's interesting terminology. The way they phrased it in the Declaration of Restrictive Covenants is because while it's a non-exclusive easement, what that means, or my position, Your Honor, is that is non-exclusive in that my rights as an owner, my client's rights as 5 lot owners has no more use rights than other owners. But it is exclusive to owners because the declaration identifies what is an owner or a member of the association. In order to be a member of the association, you must be a property owner, and the declaration grants that easement to owners. It doesn't grant it to, it's not a non-exclusive easement for anybody. If that were the case, then me being my client's attorney, if I was an aviation enthusiast, I could fly into that airstrip because it's a non-exclusive use right. But no, it's exclusive with regards to the owners. It's just that my client's rights are no greater, and other owners' rights are no greater than my client's. At the end of the day, yes, Your Honor.
I mean, isn't it your position that your aviation use is incompatible with the electric line?
Well, again, this community was built with the intention of being an air park, a fly-in. There is testimony on the record that, use means you can fly in, land and take off using the runway. Well, if they could point anywhere in the record where they provide that there is some kind of housing facility or hangars, for all planes that land, then I would say that falls within, because then my use rights are not being impinged. But there is no such thing. Each owner either holds or stages their planes in their lots. In order for me to use the airstrip, I have to be able to get to the airstrip from my lot. And these utility lines are going to prevent me from getting there. Not only that, when I'm landing, the possibility of danger.
40 feet above the ground?
Excuse me?
Aren't the lines 40 feet above the ground?
Correct, Your Honor, but the placement of, depending on where they place the poles, there is the possibility that my wingspan won't allow me to access because of the way it's. I'm not going to rewrite the plats here, but I could see that it's possible that if they place the poles in a certain position, there is the possibility of someone's plane not having access. Because remember, there's no limitation on the size of plane that you can land at Steinhatchee and Oaks.
So the poles are up.
Correct.
Is there anybody who can't get to the runway now with the whatever airplane they have now?
I'd have to brief that, Your Honor. I haven't looked into that, quite honestly. But at the end of the day, like I said, Your Honor, this is a contract right.
So the electric line is 10 feet east of the lot lines.
10 feet into the right-of-way, within the right-of-way, right. Not along the right-of-way, as is required under the plats. It's within.
And in your view, it should be on the other side of the lot line.
On the other side, yes.
And the utility says they need 10 feet on either side of the electric line.
Mm-hmm.
So now you told us that there's a 30-foot setback?
Yes.
Well, I thought your position was that on your 1.540 motion that what you wanted to put in was the 74 ordinance that said
yes.
15.
No, and I'm not saying a 30-foot setback with regards to the utility. What I'm saying is that under 74, as originally crafted, developed, this community was platted a certain way, and 74.05 was in place at that time. So it would have been a 15-foot easement into each lot And along that road.
That's where the line should go.
Should go, Your Honor. And that way we preserve the 200
the power
feet.
company says that they need 10 feet on either side. So that means, I guess, that you're talking about 5 feet west of the lot line.
Correct, Your Honor.
As opposed to
10 feet.
10 feet
East.
So in your view, the line should be moved 15 feet.
Correct. And that way we preserve the 200-foot primary surface. But at the end of the day, the reason being, Your Honor, is because it's safety. At the end of the day, the public policy of the state is that we want to would ensure safety for each owner there.
How far are the poles from the center line of Veronica Drive?
I believe they are.
Well, it'd be 50 feet, right?
It would be
60 foot.
They're 60 foot. So from the center line, Veronica Drive is 60 feet wide.
Okay.
Therefore, 10 feet in from the center line would be 20 feet from the center line. So at the end of the day, what we have is, instead of having a 200-foot primary surface as was originally developed, we now have, I believe it ends up being 180 feet.
But aren't there trees?
Or 190.
There are trees.
And there's trees.
They're east of the power line.
Yes, Your Honor.
Okay. And how does the homeowners association pay to get those removed? I mean, they'd have to assess all the.
They have powers in their declaration, the 720 to specially assess. I believe it is a safety issue, and they do have an obligation to undertake that.
And they would have to assess the homeowners.
Yes.
For the cost of it. And is there any record evidence that the homeowners are ready, willing, and able to pay the tens of thousands of dollars that's going on?
Quite honestly, Your Honor, under Chapter 720, that is not a decision for the homeowners. It's a decision for the board. The board is the ultimate decision maker with regards to special assessments. The unit owners don't have a vote, if you will, with regards to whether or not a special assessment is levied.
But they do have a vote. 75% of the owners could vote to change the
To
easement.
amend the declaration. I would argue, Your Honor, that they have an amendment right to amend the declaration. However, I would argue that amendment right does not give them the right to change the plat. They may amend the declaration, but the plat specifically carves out where the easement utilities have to be. So the fact that they want to have this and it's interesting that you bring that point up, and although I'm already into my rebuttal, the fact that they have claimed that there's this de facto amendment of the declaration, well, quite honestly, that's absurd. There are specific statutory requirements in order to amend the declaration. There are specific notice requirements. There are specific recording requirements, none of which have occurred. More importantly, they've also argued that even if they didn't have, they have a license now to be there, or they have some prescriptive easement under Chapter 96 under color of title. Well, quite honestly, there's no recorded document with regards to this license or this transfer of this easement to Tri-County, and therefore I would argue that under 96.15, the color of title is not there yet, therefore the time hasn't expired, so they don't have claimed by adverse possession or prescriptive easement to this land. But again, just to sum this up and to preserve some time for rebuttal, at the end of the day, this is about safety, Your Honors. It's about property rights, contract rights. My client is an intended beneficiary of this contract, which is the Declaration of Covenants. They've been granted this irrevocable use right, and it is solely to the owners. It is not for others to use. And the installation of these poles and the lower court's rewriting of the declaration and rewriting of the plat, basically with creating this easement, was an abuse of discretion. More importantly, their awarding of costs was also well beyond their authority. 723.11 specifically states that in order to obtain costs and fees, there must be mandatory pre-suit mediation with certain delimited disputes amongst owners and the association regarding either common areas, which this is, or the restrictive covenants, which this is.
Who raised that objection to the cost award?
Yes, that was, I believe, and don't quote me, Your Honor, but I believe that was raised. And at the end of the day, under 723.11(2) sub B, the court had no power to award costs when there was no pre-suit mediation. Thank you.
Mr. Mancebo, I will give you 3 more minutes.
Okay.
Since you used up
I appreciate
With
it,
our
Your Honor.
help,
Thank you
use
very
your-
much.
Your rebuttal time. So both sides will get an additional 3 minutes.
Thank you, Your Honor. I really appreciate it.
Morning. My name is Joe Fritz, Tampa. I represent the Homeowner Association. In my 20 minutes, 23 minutes now I see, I want to pass over 10 minutes to Mr. Dylan Rivers, who's representing Tri-County. Our interests are somewhat aligned. I think the final judgment said. I don't dispute that.
You're not going to share the 3 minutes with him?
11 and a half minutes then, Judge. Yes, good. You know, what this is about is a case that lingered in court for some 2 years, over 2 years, with their defendant doing virtually nothing. He did do some discovery. We did respond to depositions. We did respond to notices to produce, which was given kind of in a strange form. They wanted the entire white box, which every homeowners meeting, they took a white box to, which was all their books and records. So that's what they asked us to bring. We did bring it to his attorney at the time. They took 2 copy machines, 2 people all day to copy all that. We gave them everything we had, okay, at that point. But nothing happened in the case. Nothing happened until a case management conference. 2 or 3 judges had recused themselves for various reasons, which are not germane here. Finally, the trial judge, took the bull by the horns and said, we're going to try this case. We're over the Supreme Court guidelines, and we're going to trial. And at that point, another attorney withdrew, and it was given 20 days to get another attorney. I think appearance of trial counsel was made on the 19th of the 20 days. You got to ask yourself, why the delay? And the answer is because the high line wasn't up. So he won. He won by default by not having the high line up. So there was a scurry of activity at the end, but it was caused by Mr. Dola. And at any rate, we went to trial. There are 3 plats. The distinctions are different. Mr. Dola called, found the original surveyor some 30, 40 miles away from the place. We deposed him. He came to trial. You know, he was unable to tell us what the plats meant. The judge below listed in his final judgment 14 reasons why there was a latent ambiguity in the thing, and why he had to construe what was there. 14 reasons, not 1, not 2.
Well, let's talk about that.
Yes, sir.
Now, they're saying that once Plat 1 was filed, the airstrip and the adjacent roads were reserved for aviation purposes, and that nothing thereafter changed that.
No, sir, I disagree. What all of the plats have said is the airstrip, no doubt about that. But I don't see the word taxiway anywhere on any road.
But it does.
Plot 1, 2, or 3, sir.
It does say that utility easement exists along the roads except those roads adjacent to the airstrip runway.
Yes, sir. The judge covered that in his final judgment and said what he thought that meant was that when they finally did get over to Unit 3, he realized that those were wrong because of the way the trees were still there and the drainage ditches that had to be, put there that you couldn't actually get there without flipping your plane. And that also is covered in the trial testimony, that it's a crowned airstrip. I think the chief pilot of the area, 25,000 hours in the air, said as a matter of practicality, you line up in the center of the runway. The sides are mushy and go down to ditches on both sides. You cannot take a small plane through a ditch. You're going to flip way before you hit the road. And then the road, if you look at figure 1 of the final judgment, you could see the brush was the next thing you'd hit, and then the power line another, let me guess, 12, 15 feet in. But from figure 1, you could see that. You also see something else from figure 1. You see 2 wheel marks down the road, not 3. A plane makes 3, a car makes 2, right? So It has never been used for aviation or for back taxi. It has never been used for taxiway. It is not called for taxiway. What's called for aviation is the center airstrip. Your answer is yes. Unit 1 does talk about the airstrip and the road we're talking about. It certainly does. It includes that the thing. But when you read 1, 2, and 3, there's ambiguity. And ambiguity is, I would say, patent and latent.
So how do people get to the airstrip?
The judge covered that too.
You have your plane out behind your house, or in some kind of hangar, or maybe out in the open. And
well, if you look
at
it's a nice
day and you hop in it and you want to go fly. How do you get there from?
All right. The basic answer to your question is the folks that do that have a culvert in the drainage ditch, which to some degree corresponds with the roads that go east-west to some degree. And at the north end, you can drive and get onto the airstrip. At the south end you can, but those in between that want to get there, and there are several that do, have culverts in the ditches, and they cross the road and cross the culvert on 90 degrees, and then taxi.
They don't pull out to the road and taxi down to the
No.
north or south end and then take off from there.
No, they back taxi. Understand that this.
They taxi out on the runway and then go to whichever end they need to go,
Yes, sir.
depending on the way.
And I also take exception with what they say that was built to commercial standard. It is not built to commercial standards. It's never been a commercial airport. It's a grass airport, grass strip that's allowed by aviation today. Of course, the law changed, and now we're registered where we used to be, as you've seen, inspected and regulated. That is no more, but it's in essence the same as it was back then.
They say that there used to be a 200-foot minimum.
Correct. Well,
Do you take issue with that?
that is no more. The statute changed.
But of course, we're talking about when the plat was filed. They said it was a 200-foot minimum.
I don't think there was a 200. Well, we had inspections in 2002, which are part of the record, and they found no problems with the power line already there and the brush already there. So it couldn't be. It's the testimony at trial and the trial exhibits show that the Department of Transportation inspected. I think the law changed in 2002 to where they're no longer inspected. But in that report, they said no deficiencies observed in 2002. And before that, in the inspections before that, they said no problems. So that line was existing at the time, and that brush was existing at the time. So no, I don't think that it's a 200-foot drop dead sort of a requirement. No, sir, I do not. I can't imagine the Department of Transportation not spanking hands if that were the case.
Let me ask you about the placement of the poles as of the time they bought into the development. They said that there were no poles within the roadway on the east side of the airstrip on, I think it's Bell Drive. Are there no poles in the roadway there? Are they all on the
Yeah, let me tell you why. It was developed as Unit 1, Unit 2, and Unit 3. The first poles that went in, and you see that from the judge's order, they crossed the road and along the road and missed boulders and mucky areas. But the lines went into Unit 1 first. When Unit 2 came about, they didn't know you need to go from the other side. They came off from the lines in Unit 1 and fed 2, which was to the east. So there was no unnecessary crossing of a road. Mm-hmm. It was already there. It was already infrastructure in Unit 1.
But when they started the lines for Unit 3,
they had to do something.
The developer said you went under the north end of the runway.
He did.
Came out on a
pole.
And you were 10 feet
to
inside.
his house.
Right. You were 10 feet inside the roadway at that point.
Yes, ma'am. He went 10 foot inside the line from there on. The guy that actually put the stake in the ground testified at trial. Charlie Back was there. He was the developer. It was his house it was going to. And he told me where to put the stake in the ground, and I put it in the ground.
And that situation existed when the appellants bought their property in...
Oh, heavens, yes. I think that was 97, and it extended again in 2003. And I think his first purchase was 2008, if I'm not horribly mistaken, 8 or 10. maybe it was 8 and 10. He bought a total of 6 lots. But yes, it was certainly there, and the judge covered that too. He said it was visible. It was there. He never complained of a thing. He didn't complain of safety. He didn't complain of placement. He didn't complain of anything until later in life. I don't know what his game plan is, but one of the homeowner association meetings that was there, apparently somebody tried to say, well, let's put it underground because, but it turned out to be prohibitively expensive.
$25,000, right?
Sir?
How much would it have cost to put it underground?
I don't have a cost, but I do know that one of my folks here that lives there had an underground put from a pole to his house, which is right there, and it took 2 men 2 days with a jackhammer to go, I think, 25 or 50 feet.
Hit some rock, I guess, with a jack.
Yeah, it's Steinhatchee is limestone.
Well, you had to go underground across the airport, right? The airstrip.
The developer did. Yes, he did. Yes, he did. But remember, that was his house at the north end of Unit 3 that he was trying to put power to originally. And then it progressed to the south.
Now, did he ever say he made a mistake about where that line was placed?
Did he ever make a mistake?
Did he ever say he did?
Yes, the trial testimony is Charlie Back told the guy where to put the stake. He pointed it out where he wanted it put. It was 10 foot outside his property line into the road. Yes.
But the developer never said that was a mistake. I shouldn't have done that.
No, not to my knowledge, ever. And of course, there was other testimony too. One owner of the lot said, I was there looking for property the day I saw that line being staked. The guy that put the line was in there. Julius Hackett, the operating manager of Steinhatchee, of the Tri-County, he had the books and records saying where it was told to him to put, but I'll defer that to Mr. Rivers. Let him tell you what his folks said. But let's put it this way. There's no evidence to the contrary. None. He wasn't here. We, for some reason, found the surveyor. We found the guy that put the original stake. We found another guy that was buying property that day. And Mr. Julius Hackett has the records of Tri-County that all lead to the same conclusion. That's where that stake was put. It was 10 foot inside the line. Then that was 97, and then in 2003 it was extended to the south for some other hookups. And then the threats of lawsuit stopped the line from going any further. And that's where we are, why we are where we are today.
Now, the property they own, are there lots south of the property that
yes.
that the appellants own?
Yes, ma'am. I've used numbers, but I think it's like half of Unit 3 is serviced, that he has 5 lots, and then maybe 8 or 10 below it, something of that nature, which, by the way, now have power as of probably 2 months ago.
And if you were going to put the lines where the appellant says they should be put within the lot owner's setback, is there any evidence about, how many trees would that require to be removed if you're going to go in the property owner's?
My God, it wouldn't matter because you'd have to, there's no evidence, but it's significant.
It appears heavily wooded on the aerial photograph.
It's significant. The other thing, too, is, we don't have easements. And if you look at his ordinance that he comes up with, which is more in the 1.5 of the motion relief from judgment, if you look at that carefully, it says along the lot line. It doesn't say the front lot line. Could mean the side. His idea was to go between 2 lots, get easement from 2 lots, go to the back, build a road, and build the high line or the power line behind. That would require an easement from every person there.
And there's water management district property to the west. Is that correct?
Yes.
Of Unit 3. Okay.
And I've thought carefully about what we would call rerouting the line to behind the lots, and it's another version of the word gerrymandering. It's just that's ridiculous. Have to get every lot owner to give an easement off the back.
You're running into Mr. Rivers' time pretty significantly.
Oh, I see it.
So
thank you, sir.
Save him some.
Please the court, Dylan Rivers for Tri-County Electric Cooperative, Inc. I think what first needs to be pointed out is that We had a trial on certain issues. We had a Rule 1.540B hearing for 2 or 3 hours on some new issues, and now we're having an appeal on still more different issues, and it's just improper. First and foremost, this issue of an irrevocable easement was never at issue in the trial. Certainly the covenants were in the record. I mean, covenants were recorded in the public record. The judge could have taken judicial notice of it. It was one of the first documents we put in. It was stipulated to go into evidence. The argument was never made that some irrevocable easement somehow eliminates any ambiguity and resolves all these problems. That would have been the first thing out of their mouth at trial. It was never out of their mouth at trial. And as I say in our brief, a review of the entire record index does not reveal the term irrevocable easement anywhere stated on the record at trial. It's not there. And this court has previously said in Pensacola Beach versus King, in order to be preserved for further review by a higher court, an issue must be presented to the lower court, and the specific legal argument or ground to be argued on appeal for review must be part of the presentation if it is to be considered preserved. Citing a statute, putting a covenant in the record, making some vague reference to something did not give the trial judge the opportunity to rule on that issue, to make findings based upon it. It simply wasn't at issue at trial, and it is woven throughout their appeal.
How would you state the issue that was tried?
I would say the issue was almost a tacit admission by the appellants of there's ambiguity. We just want you, Judge, to resolve them in the manner that we think they should be resolved. I mean, I frankly think that's the issue, because I don't recall there ever being any argument that these plats are 100% perfectly clear. All you have to do is connect these dots, Judge, until after the fact when we hear about this supposed missing ordinance and this supposed irrevocable easement. I simply don't think an argument can be made with a straight face that you can look at these 3 plats and say, well, it's perfectly clear to me, and I can walk you through that, why that is the case. First of all, with regard to interpreting the plats, there was at least some mention.
You say they never argued that Plat 1 controlled?
No, I would certainly concede that point, and I think the argument was made that Plat 1 is perfectly clear, and because Plat 1 controls, because it controls all the property that was platted in Plat 1, there's no ambiguity. What I don't think there was ever contradictory evidence put into the record about was when you read these plats together, as you have to, once the Unit 2 was platted and once Unit 3 was platted, the ambiguity was then revealed. I would concede that Plat 1 on its face is perfectly clear. That utility easements are to be along roadways except along the airstrip.
Would you concede that Plat 3 doesn't have any roads in it?
Absolutely, and that's one aspect of the ambiguity.
So isn't that their argument, that Plat 1 is perfectly clear and that Plat 3 doesn't have any roads in it, and so Plat 1 controls?
Well, if that is the case, then the developers have configured a development with an entire phase of the development with no access to utilities. And that can't possibly, whatever the intent of the developers was, that can't possibly have been the intent to create Phase 3 with no access to utilities. Because what—
Well, their answer to that is that the then existing ordinance created the possibility of a utility easement along the road.
A couple of issues I would point out there, Judge. First of all, unfortunately, that issue wasn't presented at trial. That issue was presented at the Rule 1.540 motion. So the trial judge, to the extent there was any opportunity to address that issue, it was in the context of belatedly presented evidence that was supposedly new evidence, but I find it hard to even make the argument that an ordinance that existed in the 70s or 80s is somehow new. It's an ordinance, and whatever the county's record-keeping process may or may not have been, they eventually got their hands on it, and I don't think there was a showing that they tried to get their hands on it and they were thwarted in that effort. I mean, they say it was just stored in some strange room and they just now got a hold of it, but be that as it may, the trial judge also ruled, even though he didn't think they met the standard of a 1.540 motion, what he said was one of the critical elements of that is this supposed new evidence would have changed the result, and it wouldn't have changed the result. And here's why it still doesn't eliminate the ambiguity, is because you have plats that say along the roadway. I mean, along, even if you want to consider the supposedly lost ordinance, Does along mean, and even if you want to accept their argument on the irrevocable easement, that a utility easement could never be within the roadway, you still have a question of, does along mean on the boundary line separating them, or does it mean off onto private property owners? And I don't think that issue, at the end of the day, is one that has never been resolved. It's one that Mr. Croft himself.
The surveyor said he didn't know, right?
The man who drew these very 3 plats, I asked him on the witness stand, and he could not tell the judge what along means in that context.
And what is our standard of review when the trial court resolves an ambiguity based on some record evidence?
I'm glad you brought that up, Your Honor, because there was at least some mention or some dispute in the briefs about the standard of review, and I would submit that it's incorrect, as the appellants propose, that this is de novo review. The cases they cite deal with purely legal issues that were resolved on summary judgment, and 2, in enforcing an arbitration clause. They were a court's purely legal interpretation of a contract without ambiguity. In this case, we had a full-blown trial about ambiguity, so the only purely legal question is there ambiguity? And I think that's absolutely clear in the record. If there's anything that's clear, it's that these plats were ambiguous. I mean, by the very fact that my client thought they knew what they were doing, but now the appellant says, no, you didn't know what you were doing. I mean, those are 2 presumably reasonable people with differing views of how to interpret these plats. We actually had the surveyor who couldn't resolve that ambiguity for us. I mean, I think if there's anything that this case has taught us, is that there's ambiguity. Second thing I wanted to address is that if there's anything this case has taught us, or excuse me, if there's anything that was litigated in this case, it's the issue of safety. And to now come and make the argument that their entire argument is premised on the notion that at the end of the day it is safety, I haven't done a page count, but I would say 1/3 of the record of this case at trial was devoted to discussions of safety issues and these parade of horribles about what may or may not happen. And what the judge ultimately found, which this court shouldn't disturb because it's purely a factual issue, what the judge found is, I'm not disagreeing with you that these things theoretically could happen, but you haven't presented me any evidence of anything that has happened. You bought your lots with these poles clearly visible in their place. You've owned them for over 10 years. You testified that you bought these lots with the full intention of flying in and out of this community. Why are we only just now hearing about all this? And ultimately, the issue of safety, as their own witness, Mr. Thuy, testified, the issue of safety is a matter of degree. It's not a matter of black and white. It's you be as safe as you can under the circumstances. And if there was a safety concern, why didn't we hear about it from anyone other than Mr. Dola? We heard from witnesses who've been flying in and out of this airport for years. We heard from a commercial pilot who flies enormous jets all around the world who said, I don't have any problem with where these poles are. I'm perfectly able to fly in and out of this community. But at the end of the day, again, those are all factual issues that I don't think this court should disturb.
Can I ask you one question before you run out of time? From the perspective of the electric co-op, what should it have said? What do you usually see when everything is done right that directs you and the homeowners or the homeowner association where the line is supposed to go? What does the correct form of easement say, and what does it look like?
Well, I think that could be resolved in a couple of ways. First of all, you could have deed restriction, or excuse me, not deed restrictions. You could have placed in the deeds where every lot within this community has a 10, 15-foot, whatever easement. That's not the case. You could have them clearly depicted on the plats, which, as I pointed out in our brief, it was a statutory requirement, and that wasn't done. The third potential way you can do it is going to each and every owner and getting an easement from them. And my client does have recorded easements for what we call drop lines, where we come off the main line and put a pole down to someone's hangar or their house. They do have easements for some individual lots, but there is not any sort of, I mean, to answer your question directly, there is not a way that absolutely has to happen. There are different ways that could be accomplished.
Okay, thank you.
I'll yield the rest of my time. Thank you.
Your Honors, if I may, I live my life by a certain way, and it's saying that it's hard to know what the right thing is, but once you know what it is, it's hard not to do it. The fact of the matter is the association knows what the right thing is here. And the right thing is we need to abide by what the plats say, where these poles have to go, and the safety and well-being of my members and my owners. The fact that a power line is no more a safety threat than this oak tree that I have failed to maintain doesn't make it less of a safety concern. The fact that there are other hazards doesn't make this one less hazardous. It's still a hazard nonetheless. I'd also submit there was argument regarding the surveyor and the surveyor not being able to interpret. Well, the surveyor is not an attorney. A survey can tell you this is what the survey says, but a survey cannot legally interpret what it means. It can tell you the point of beginning is here. You take it, this far, whatever. But it's not, to legally make a determination of what along means in the plat. That's for an attorney or for a judge to decide.
Is there only one possible definition of along?
No, I'm sure that, and that's interesting. I don't know that using Webster's dictionary would be correct. Maybe we would want to look at the tenets of surveying and whether or not along is defined within a surveyor's framework and their terms of art. But nonetheless, Ordinance 74.5, as Your Honor correctly said, it does have that 15-foot right away. My clients made over 6 or 7 different requests to the county to provide this ordinance. And notwithstanding the numerous requests that were made, they were provided it after the fact by the city manager, the county manager. I would also submit that to this day, that ordinance is still not available online or recorded. So yes, the missing ordinance was missing. We're not talking about smoking guns and stuff here, but the fact of the matter is that had that been made available by the county at the time of the trial, I don't believe that we would be here. With regards to the issues of how the taxiway and the argument that this was never intended to be a taxiway. Well, I would submit that how do the owners of Phase 1 get onto the airstrip? If those roadways were never to be used as taxiways, how do the owners of Phase 1 out here, when the airstrip is over here, and now that Phase 2 is built, how do they access the road strip? There's a lake in between Phase 1 and Phase 2. I would argue that the roadways were built for dual purposes, for vehicular traffic as well as airplane traffic, and therefore they were intended as taxiways. And because of that, when you take Plat 1, Plat 2, and Plat 3 in pari materia, you will see that Plat 1 controls. The roadways were never a part of Plat 2 or Plat 3, and therefore the restrictions on the easements are valid and standing, and Phase 3 could never go within, but along. At the end of the day, it's along, not within, Your Honors. And because Phase 3 was never part of Phase 1, I would submit that the easements and the judge went beyond their scope of authority. Thank you very much.
Thank you. Being that we have no other cases to come before us today, we're adjourned.
All rise.